Welcome everybody to the webinar, and we will start in just a few minutes. So if you're joining us, just make yourselves at home and we'll get started with John in just a few moments.
Good morning. My name is John Shoup, and I'm an attorney and director for the Indiana Agricultural Law Foundation. I want to thank you all for attending and welcome you to our second installment in our series titled How to Make More Money with Your Land. Hopefully most of you were able to join us last time. Jason Lusk had an excellent presentation titled Diversification 101. He talked about a lot of different options, including the subject matter that we're going to deal with today. I also want to thank Indiana Farm Bureau and Andy Tower, the director of our public policy team at Indiana Farm Bureau, and Sarah Beth Aubrey from Indiana Acre, the Indiana Coalition, or Indiana Agricultural Coalition for Renewable Energy, for partnering the three of us today to bring you this presentation. Again, as Andy talked about last time, there are multiple diversification options, and we just want to stress that our purpose here is to educate, is to give you information, to arm you with more facts, information, considerations as you think about the future of your operation. As Jasmine mentioned, questions, we encourage you to stick those in the chat. Sarah, Andy, or I will take a look at those and certainly pose those questions to Terry at the conclusion of her presentation. Also, just a quick reminder, we have one more installment in our series that will be at the same time next Thursday. Interesting producer panel talking about some of the diversification and renewable energy information that were discussed throughout the program. And again, we encourage you to attend that as well. The last thing, last time we had a bit of a technical issue. We don't foresee any problem today, but if anything happens, we encourage you just to log back on. We'll be here, we'll continue things. So in the unlikely event that something happens, we encourage you to sign back on and we'll just keep going. With that, I'm very happy to introduce our speaker today. I've had the opportunity to work with Terry Hall for a number of years, specifically regarding wind and solar leasing. Terry has been advising clients in the renewable energy space for over 15 years. She's represented landowners, financial institutions, developers, and local communities as they take a look at this renewable energy option. Since retiring from her practice and partnership with Faegre Baker Daniels here in Indianapolis, she's continued to maintain the practice in renewable energy, primarily representing landowners and local communities dealing with considerations relative to wind and solar leasing. So with that, again, thank you for attending. Stick your questions in the chat, and I'm happy to turn things over to Terry Hall.
Okay, thanks for having me on. It says I cannot share screen with other participant is sharing. So how do I share? So can I?
Sorry, I've stopped sharing.
Okay, so let me.
You should be all right.
Find it here. Hopefully this is it. Okay. Hopefully you can see a title slide there. This is wind and solar farm leases and my name on it. Jasmine, can you see that? Am I on? Okay.
You're good.
You're live.
Well, thanks for having me on. As John said, he and I have done this kind of presentation, for quite a while over the last 3 or 4 years, to different organizations and different areas of the state. I'm currently working with quite a few landowners who are considering leasing their farms or property for essentially commercial scale wind and solar farms. And I didn't intend to continue to have this big of a practice, but the interest in development of solar and wind in Indiana has really picked up in the last 3 to 4 years, as those of you who are on the webinar probably have been approached or have heard of people who are trying to develop wind and solar farms in the state of Indiana. And like I said, these are mainly commercial scale. They could be anywhere from 800 acres to over 3,000 acres in size. They're primarily located in agricultural districts, and that raises a whole host of issues, both for the landowner and the farmer, because it is going to be a change in land use, more so with solar than with wind. It also raises issues for the community and the county with respect to their land ordinances or their wind and solar ordinances, if they have some. And then recently, because of the increased development pressure, the opposition to wind and solar development in Indiana has become a lot more organized. And it causes some controversy because these kinds of developments can't be developed without permits from the county, whether the county has zoning or not zoning. There's usually some kind of permitting process, whether that's an improvement location permit or a drainage plan or a road plan or something like that. There are, let me see if I can get to, in the solar and wind development in Indiana, there's currently very large solar developments underway in Indiana, primarily in the southern part of the state. There's at least 3 large developments. And while wind development is slowed, it's still going on primarily in the north and eastern part of the state, with phase 2 and phase 3 of existing wind developments. And recently, I've been working with more communities and counties on developing solar and wind ordinances themselves. I'm currently working with Posey County, who adopted, helped them develop their solar and wind ordinances last year. And they're currently considering some changes to those ordinances, as well as it has attracted development to the county. But like I said, there's more opposition growing in Indiana to the types of commercial scale solar and wind development. There's a difference, and this is kind of a technical presentation, and I apologize for that in advance, but what we're talking about is, as a landowner, and I'm going to be speaking mainly to the landowners in the presentation today, of considering a long-term lease and a land use change of your farm. These leases are in wind are 40 to 60 years long. For solar, they're a little less, sometimes 35 to 50 years. In a wind lease, because the turbines are spaced far apart, the owner can continue to farm the property. However, it is cut up by the turbines themselves. So if you've got someone who cash rents your farm, or if you farm it yourself, you're not going to be able to make those long, straight rows, turn around at the end, come back. You're going to have to go around the turbines that are going to be on your property. So it does interrupt the farming process somewhat, but you will be able to continue to use the land. In solar, it's a different situation. Where the solar panels go on, there is no farming. So if you've got a 100-acre plot and they put solar panels on 70 acres of it, then you're not going to be able to farm that 70 acres, but you'll be left with 30 acres. And depending on how they site the solar panels, You'll either be able to use that property for farming purposes, or it'll have to just be maintained and mowed. And that's one of the things you want to discuss with the solar company if they are, if you're considering a solar lease. The payment terms are a little different. They both start out with a per acre payment, usually a fairly small per acre payment, somewhere between, I've seen everything from $15 to $250 per acre, depending on the company and the type of development that they're doing. And then as that's during the development period when the developer has not started construction. Once they've started construction and go into operation of either the wind farm or the solar farm, then the payment structure changes. For wind, it's usually based, you still may get some small per acre payment, but it's going to be based primarily on the megawatt generation of a turbine, if a turbine is located on your property. If a turbine is not located on your property, then you'll get the per acre payment, but you won't get the megawatt payment. Some leases I've seen have had a kind of a revenue sharing situation to try to even out the landowners who are participating in a large wind farm, to not disadvantage so severely those parties that don't get a turbine. In solar, it's kind of the same situation. You start out with a per acre payment, but I haven't yet to see, I think I've seen one lease on a solar farm where you got a megawatt payment. Usually it is in a solar farm, it starts out in the operation phase with a higher per acre payment. 3 years ago, they were around $600. The most recent lease I've been working with a landowner on is $1,000 an acre. And then there's usually a 2% or some kind of inflation adjustment per year. And then every 10 years, there's an adjustment upward of perhaps $100 per base acre to account for the increase in appraised value. So in wind farms, your payment structure is based on how much wind energy the wind farm is going to generate. In a solar farm, you're based on the actual acres that are used and covered by solar panels. There's, of course, a different landscape view from wind and solar. Wind farms you can see from far away because they're very tall. Solar you can't see from far away, but since the panels are placed as close together as possible in order to get an efficient use of the land, they're going to have a more immediate impact from a visual impact to your neighbor. In other words, instead of looking at a cornfield across the street, they're going to look at a sea of black glass, which is a solar panel. Construction of a wind farm is more intense and takes longer. They have to bring in huge cranes and large equipment in order to construct and build those turbines. Solar farms usually can be built quite quickly. It's kind of like almost putting together a tinker toy situation. They've got racking that they put in, they drive steel poles down into the ground, put up the racking, and then they just bolt the panels on there. And most all of the, unless it's not practical, most all of the electric transmission collection is underground. Most leases also have a decommissioning statement, and decommissioning just means that at the end of the useful life of the development, whether it's wind or solar, the lease requires that the developer dismantle. If a new lease is not negotiated, then they dismantle the facility and haul it off and restore the land to its original use. We haven't really gone through that in Indiana because we haven't gone through an entire life cycle of either a wind or solar farm yet. So people are, there's an agreement in the lease to do that. As far as any problems concerning that, we haven't hit them yet. One of the reasons that I've like to talk to landowners when they come to me and ask for my assistance in helping them negotiate a lease with a wind farm developer or a solar farm developer is the farmer needs to understand that these leases are different. They're not like the normal leases that you see for cash rent. They're not like the normal leases that you would see for pasture rent or even government leases. The developers have a particular set of issues that they have to get through in order to actually turn on one of these renewable energy developments and start generating electricity. And all of those steps include getting control of the land, getting permission to put electricity on the grid, going before the IURC to get either permission or a declination letter that says the IURC won't have, and the Indiana Utility Regulatory Commission won't have jurisdiction. They have to negotiate some kind of agreement with somebody that's going to purchase the electricity if they're going to sell it into the grid. They have to find financing. They have to determine the energy resources that are on the land. And then they have to, plan for operations. They have to go through whatever county or local community processes are in place to get permits. A lot of times they are looking for some kind of tax relief or tax abatement, and in exchange offer to make an economic development payment to the county. And at all of these different steps, that development can be stopped. They could not get permission to get onto the grid. They could not successfully negotiate an offtake agreement, a power purchase agreement. Their financing could fall through. The permit could be denied. And unfortunately, the first thing that they have to do is get control of the land. So the landowners are the first step in all of these contracts and steps that the developer needs to negotiate a lease with. As a result, these leases are just, and the developer is very honest about this, these leases are very one-sided as far as the rights and responsibilities go. The lease, the land, these leases have an absolute right of termination given to the developer. And the right of termination given to the landowner is very restricted, even in the face of non-payment. Let's go to the next slide. So what that means is that for farmers, especially who are in the process of actively farming a large acreage, you could enter into one of these leases with the understanding that it could be 3 to 4 to 5 years before the operation actually begins or construction actually begins. And at any point during that time before operation begins, the lease could be terminated. And what this means is that if you are making a 5-year plan, or you're trying to make an equipment decision, or putting in tile or fertilizing or something related to your agricultural operation, you have to make a decision to go forward with that 5-year plan or that equipment purchase, with the understanding that you've entered into this lease. You may not be able to use that equipment because they may start operations or start construction, and then you're stuck with the equipment. You got to sell it back or whatever it is that you need to do, or you delay those capital improvements or equipment purchases, and then the lease gets terminated by the developer because if something happened, they didn't get a permit, they didn't get financing, they didn't get on the grid or whatever it was, and then you're left out in the cold. And like I said, the developer can terminate at any time with no cause. They just have to give you 30 days notice, and they'll pay you what they owe you up to that point. But beyond that, you're on your own. You also have to realize, and this is a common misperception, because normally let's say if you've got a 100-acre plot and you lease it to somebody to farm it, and you lease the tillable acreage, so that's 95 acres out of the 100 acres, and you do it for cash rent, and so you're going to get paid per acre of 95 acres. And so you're essentially leasing all of your farm. Under wind and solar leases, wind leases are a little different in that they do in fact lease most of your property, because they have to have control. They have to have the ability to get from one turbine to another. Solar farms are a little bit different in that while we all know what the tillable acres are on the property, you may not know what the solar farm acres are on the property. Out of that same 100-acre plot that has 95 tillable acres, there may only be 50 acres that are suitable to actually put solar on. And the way these leases are structured, you're only going to get paid for the acres that are actually covered with solar panels. So as you're looking into whether or not you want to enter into one of these solar leases or wind leases, one of the things you need to push the developer on, and they're pretty reluctant to give you this information, primarily because they may not know right away, is where the solar panels are going to be. Because, you know, it's not necessarily the case that if you have a 100-acre plot that's in a rectangle, that they're going to take 50 acres and they're going to leave you with a nice 50-acre square that you could continue to farm. They may leave you with 5 acres here and 10 acres there and 15 acres that border a ditch and that go through the farm that you'll have to maintain unless you negotiate that they have to maintain it. And you're only going to get paid for the land, the acres that actually have solar panels on them. And at the time you enter into the lease, neither the developer nor the landowner knows exactly where the solar panels are going to be, because in the beginning, the lease is for the development purposes, in which for 2 or 3 years, they'll put instruments out on the land to measure the solar resource and design essentially the solar farm. So as you look at the other things that they'll do is that they'll also have exclusive easements either for the solar or wind or water rights, right to drill wells on the property, right to remove improvements, right to cut down trees or anything that interferes with the solar resource or the wind resource. And so if there are parts of your property that you don't want developed or you don't want cut down, or you want a larger setback from a residence that's on the property, whether it's your residence or a rental, then those are things that you would need to negotiate in the lease up front. My experience has been that the developers are pretty easy and somewhat to work with about making accommodations if you let them know in the beginning what your concerns are. So let me see if I can get to the next slide here. Okay, there you go. Oops. Too far. So we talked about some of the things that are on this slide about things to think about as you're considering whether to lease your property for solar or wind leases. We talked about a little bit about the difference between what your property is and the acres that you'll actually get paid for. It is a long-term commitment. Most of us who would enter into a solar lease now are not going to be around at the end of the solar lease. So if you are planning on passing down, if your farm or your property is part of your estate planning, you may or may not, I've had it go both ways, want to bring in your heirs as far as in discussion of whether to change the property from a farming operation into a energy generation operation. There is some concern about whether, or not concern, but unknowns as to whether it increases or decreases the value of the property and your ability to sell it. You will be able to sell the property in whole or in part, but it'll be subject to the lease. I have sold farmland that has had a subject to a wind lease, and it actually turned out to be a selling point for the buyer. They liked the fact that it had a wind lease on it because that provided them with a long-term stable source of revenue that was not going to be subject to the vagaries of the agricultural commodities market. There are some issues related to things that you need to think about. The developer could go bankrupt, in which case you might have a half-built solar farm or a half-built wind farm on your property, and potentially, the bond to remove the facility has not been put in place yet, because that usually, unless the county requires it under an ordinance, the bond in these leases is usually not placed until the 10th or 15th year after operations start. The developer has the absolute right to assign its rights in the lease to others without your consent. Hopefully it would be an assignment to a responsible party, that it would be subject to all the rights and obligations under the lease, but it would not be the same entity that you started dealing with in the beginning. That was more common when these kinds of leases first started. It's become less common now. The wind and solar development field has kind of narrowed and merged down into some fairly large companies that, for the most part, do the design, build, operate. And there's not as much selling and assignment as there used to be. One exception to that is that there has been, with the changes in the utility market and the changes in legislation, a lot of the utilities that were public utilities that were happy to just purchase electricity from private developers of wind and solar have gotten more into direct ownership. So there's a solar farm down in southern Indiana that was announced. It's being developed by a private developer, and it was announced that the private developer, the solar farm hasn't been built yet, but it was announced that the private developer has entered into an agreement to sell the farm once it is completed to a public utility, which is Vectren or Centerpoint. Vectren merged with Centerpoint about 2 or 3 years ago. And so then you would have a public utility that would be your tenant instead of the private developer that you had originally entered into the lease with. How that might change things is a little bit unknown. It hasn't seemed to change things in those projects where this has already occurred. But it is something to think about. Let's see. Let's go to the next slide here. Some of the lease terms and issues as you're looking at these leases, and I will tell you that I would have said last year that most all of the leases are fairly standard. That has changed. There was a model lease kind of put out that the developers had, for the most part, adopted. They have seemed to have gone their different ways, and the leases are diverging in a lot of ways at this point. So you need to pay close attention. I've seen leases that are 12 pages long. I've seen leases that are 65 pages long, and they can have a lot of difficult terms in there that you really need to understand what you're potentially obligating yourself to, and what rights you're giving the developer to do with your property. Some of the things that you want to look at and just kind of mark down on a piece of paper as you're reading through the lease terms and issues. At least this is how I go through it when I start in to read a lease. I want to understand how many acres they're actually going to lease in the beginning, and what is the discretion that the tenant, the developer, will have to terminate the lease as to some of those acres. In other words, if they lease 200 acres in the beginning, is there a provision that says they can, at the end of 2 years, release acres from the lease if they don't need it? If they do release acres, but they've gotten an easement over the acres that they're releasing from the lease, do they get to keep that easement? I had that in a situation not too long ago with a lease where the developer essentially leased the entire farm, but the lease allowed the developer to remove acres from the lease. But if an easement had been granted across the property while it was under lease, the easement continued indefinitely to serve the project without compensation. Now, we caught that and we changed it so that the farmer would have to be paid for that easement on an annual basis, just as if it was still in the lease, or the land would have to remain in the lease. But you need to closely read some of these leases to make sure that you understand how much discretion the developer is giving themselves. You need to understand the difference in the payment structures and the development and operating terms. Some of the wind leases have quite complicated payment structures related to, I think it was an attempt to share the profits of the wind farm, but also share some of the risks, in that there was a payment per megawatt plus a smaller payment per acre, or so it was the greater or some kind of profit share based on the reporting of the wind company. And I'm not a real big fan of that because in order to understand the profit design of the wind company, you'd really have to hire an accountant to figure out if they're actually paying you what they're supposed to be paying you. And while there was a provision in the lease that would allow for you to hire an accountant if you wanted to challenge what the wind company was saying that you were owed, you'd have to pay for that accountant to do that advising. So it wasn't a really good idea, and I think that is kind of going by the wayside. The developer usually has quite a lot of discretion over the location of improvements and the control of the design, which means that they will work with you and consult with you on where the turbines go, or where the power lines go, or where the solar panels go. But the ultimate decision is theirs, and the lease is very clear that while they will take your wishes into consideration, whatever they finally come up with is what it's going to be. Now, like I said, most of the developers that I've worked with have made reasonable accommodations as far as the location of roads or the location of overhead lines. But to the extent that you can get as much information up front, or as many promises up front that says, I don't want my mother's house over here to have any, facility closer than 500 feet on all sides, then you need to ask for that up front. Or if you have a specific area of woods that you don't want cut down, or if you want to timber it yourself and retain the income before you lease it to the wind farm, or put that in the lease that you can timber it and remove the timber and sell it yourself, then you would want to put that into the lease in the beginning. You will get paid for, there should be a provision in every lease. I had one lease that didn't have any provision, and we were successful in getting it in there. You should be paid for any damages that the tenant causes during its tenancy or during the construction period. And let's say that, you've got the crop planted in April, and for some reason, because of some external thing that they have to do, or time frame that the developer has to meet, all of a sudden they've got to come in and start construction in September. There should be a provision in there that will pay you for the crops that you're going to lose. And you need to pay attention to this if you've got a tenant farmer, because if your lease structure with your tenant farmer says that unless you tell him by October 1 of the year before the crop that they've got a right to plant a crop, then you're going to either need to put in the solar lease, you're going to either need to put into the solar or wind lease, that they have to notice you that they're going to construct next year before that, your obligation to tell the tenant farmer. Or if they prevent the tenant farmer from farming, then they have to pay the tenant farmer the value of his crop, and they've got to pay you the construction rent if they don't actually construct. You want to make sure that you're never in the position of, they tell you they're going to construct, you don't plant a crop, and then they don't construct because of something happens. You want to make sure that you're going to be paid during that time, because otherwise you might lose your farm income and not have it replaced by the operating income. There's usually always a provision in there for if they damage tile during the construction or operation, or if they have to take down a fence, then they can put fences back up. And then like I said, there should always be some kind of provision in there that says how you can get a financial assurance that at the end of the useful life of the solar farm or the wind farm, that those facilities will be removed and the land will be restored for agricultural purposes, or for the same purposes that it was being used for before. I think we kind of talked about this. These are the phases and payments and terms during which you get paid. So I'm not going to go over that again, except for the fact that I'd like to bring to your attention that all of these, the terms of your lease and the payments of your lease are all keyed off of certain particular dates or activities in the lease. And you want to make sure that that's all spelled out, so that if you're paid during the development phase, while you're still farming the land, and the developer has leased the property and they're paying you $20 an acre, but they're not really doing anything except just researching to see, where they would design to put things on. But then they want to start construction, and then you're supposed to have, higher payments during construction because you won't be able to farm during that period of time. You need to understand what is the start of construction. Is it a notice that they send you in writing that says we're going to start construction? Is it turning the dirt? Is it, pouring a concrete pad? Because you want to make sure that you understand when certain things will happen and when you will have notice of when certain things will happen. Specifically because, as I mentioned before, you want to make sure that you're never in the position where you can't farm and you're not being paid for the solar or wind farm. So each of these activities or terms that start new phases, new payments, new rights of either you or the developer, you need to make sure that you understand where those are in the lease. and that they're also in the lease. I have had situations where, you know, they said, we're going to start paying you $1,000 an acre once we start commercial operations. And I said, okay, but commercial operations are not defined anywhere in the lease. What does that mean? And they said, well, you know, we'll let you know. And I said, well, that's not good enough. We need to understand when we're supposed to be getting these $1,000 an acre payments instead of the $500 an acre payments we were getting during construction, or the $20 acre per acre payments we were getting during, you know, the development phase. In addition, you need to make sure that if there's a provision in there, which there is in all of them, that says the developer can release or terminate the lease as to some acres at any time, that if there is a payment that is being paid in arrears, so let's say that they're going to pay you $40 an acre on an annual basis in arrears during the development phase, and they initially lease 100 acres, but then, you know, a month before you would get that first payment, they release 50 of those 100 acres. What the lease will say usually is that they don't have any further obligation to the payment on those acres once they're released. Well, that's not fair. I mean, they can't occupy the property, even if they haven't done anything. They can't occupy the property, and you count on that payment coming, and then release acres to reduce their payment because the payment hasn't occurred yet. So you need to make sure that there's language in there that says if they release acres, all the amount of money that is accrued for those acres is still owed, and is not released, so they don't lose that obligation. I won't get any more technical than that. I'm just trying to bring it to your attention that these are the kinds of things that are very kind of buried in the leases, but you need to tease them out and make sure that you understand when your rights and responsibilities and your payments start and when they might stop and which acres they might be reduced on. Let's see, I think we talked about this. I will talk about the bottom phase, one of the other payment structures that I didn't talk about, in addition to the per acre payment, is if they build roads, and sometimes they usually try to stay on public access roads, but if they have to build a road across your property in order to get from one transmission line to another, or they have to run a transmission line underground to connect one set of solar panels to another set of solar panels on a different person's property, then they will pay you for those easements. Most of the time it's a linear foot payment, and it can be anywhere from $1 to $2.50 per linear foot for an overhead transmission, and $1 per linear foot for roads. But you need to make sure that those are annual payments, that it's not a one-time payment, because the burden to the land of maintaining that easement or maintaining that road should be paid annually, just like an acre payment should be annually, not a one-time payment and then we're good to go, because you granted the easement for as long as the lease occurs, and sometimes longer than the lease. And if they, like I said before, if they release that acres that surround that easement, you still want to get paid for that easement. So that's just one of the things that you need to think about. The bottom bullet point on this payment slide, I'll just bring to your attention. This comes up sometimes when I'm talking to clients and they say, well, you know, I know that they're talking to 4 or 5 people around me and my neighbors, and I know one guy that signed up, but I don't know if the other guys are going to sign up. And, you know, I heard somebody got $600 and somebody else, my lease says $800, but somebody else told me that they were holding out for $1,000. And you want to make sure that these leases have what's called a most favored nations clause. And what that simply means is that in any one project, the developer promises to treat everybody equally, so as not to penalize someone who signs up early. So if the developer hits you first and you say, hey, this looks like a great idea, I really want to do this, and you accept an $800 payment, and then another landowner who's got 4 times the amount of acres that you have and is in a place where the developer, it's critical that the developer has that piece of property, otherwise they can't put the project together. And that person negotiates $1,000 an acre, then there should be a clause in your lease that says if the developer subsequently negotiates a better financial payment with a landowner in the same project or within 5 to 10 miles of the project, that the developer has to come back and offer you the same financial terms. That's usually in a lease. I've run up against some of them that it hasn't been in. And in those situations, while the developer refused to put it in a lease, they did put it in what's called a side letter agreement. That's just as enforceable, because you want to be treated all the same and not be penalized if you're one of the early adopters. We talked about most of this. This primarily goes to the developer having sole control. I do want to bring up one thing, and that is on buildings like operations and maintenance buildings or switching stations, or transmission buildings, substations, or something like that. Usually the lease will have in it an absolute right to purchase by the developer land to put a operations maintenance building on or a substation on. I've had some landowners who absolutely do not want that in their lease. They don't want, they're perfectly willing to negotiate later on with the developer if they want to buy some land, but they don't want an absolute right to buy on the behalf of the developer and a forced sale on behalf of the owner. Now, usually you're only talking about, 3 to 5 acres. I have yet to see a developer buy an entire farm, and they don't want to, otherwise they wouldn't go through all this process of leasing these properties. But if you're concerned about the forced sale of any part of the property, you'd want to negotiate that out of the lease. And most of the time, unless your property is right next to the switching station or it just makes so much more sense to have the building on your property than it does on any of the other properties that are in the project, then you can negotiate with the developer right then and there as to which property and how much and that kind of thing. They usually will pay somewhere around 125% of the appraised value of the property. We talked about this earlier on when we were talking about what kinds of leases these are, and won't belabor this much more anymore, but I will talk about the owner's right to terminate. I think I mentioned that the owner's right to terminate the lease is really constrained. Essentially, your only right to terminate the lease is if you are not paid, but that not payment period can continue up to 180 days. And in one situation, in fact, one of the leases that I'm currently looking at with a tenant, with a landowner, the right to terminate is only available to the landowner if you get a judgment against the developer for non-payment and the judgment has been, is no longer appealable by either side. In other words, it's a final judgment that's non-appealable. And there's been an order of the court ordering the developer to pay, and the developer does not pay within the period of time that the court orders. That is the only time that you can actually terminate the lease. That is an extreme remedy, and one that we are talking about, because that essentially, a civil case for non-payment could last 3 to 5 years, in which case you wouldn't get paid during all of that time. Now, I will say that if the developer is that bad off, you probably got other problems too, but I just want to make sure that before you sign this lease, once you sign it, you're in, and there isn't much you can do to get out of the lease. It won't restrict your right to sell the property or to divide the property, but it will still be all subject to the lease. On the next slide, we'll go through a couple of other things that you want to think about as you look through these leases and consider your options. We talked about the damages that they would pay for. You need to make sure that the insurance provisions that the developer has put in the lease of what they have to carry is in there, that they have insurance, and that you're indemnified for any damages that they cause or injuries that they cause. You may also want to, and I've started doing this more recently, check with your own insurer, because you probably have most of these indemnification provisions, which essentially says, I promise to hold you harmless if I do something that hurts you, and you promise to hold me harmless if you do something that hurts me. You may want to check with your own insurance carrier or broker to make sure that if you change your land from an ag use and you have a general liability insurance policy in case somebody gets injured on your property or something like that, and you change your land use from agricultural use to this solar farm or wind farm, that your insurance policy is not going to be affected. Most of the time, the insurance person comes back and says, no, that's no big deal. But there has been at least 2 cases where the insurance company came back and said, no, you have to have a rider on your insurance, and it's going to cost an extra X number of dollars per year. And we negotiated with the developer to pay that additional insurance cost. So that's something that you may want to think about. The other thing that's normally in these leases is that there is a waiver by the owner of any and all health effects from the wind farm or the solar farm. So in other words, once you sign this lease, you will not be able to sue the wind farm if the vibrations or the noise or the flicker or the shadow or the glare or anything else affects you. You have fully waived all of those potential injury rights. And then there's usually a provision in there that says whoever wins the lawsuit, if there is a lawsuit related to any of these things in the lease, they have to pay the other side's fees and costs, including their attorney's fees, which has become fairly standard in contracts. I don't particularly like that because it has a tendency to prevent people from enforcing their rights. But it's become a standard part of the situation. Just quickly here, I want to talk about taxes and zoning of your property and assessment of your property. The leases will always, usually things that you want to check on, the lease will say that the developer will pay all personal property taxes related to the facilities that they place on your property, which is normal and standard. But there should also be a provision in there that says, if for some reason the assessment of your property under an ag assessment is changed to a higher real property assessment, because it's now covered by a wind farm or solar farm, then the developer will pay that incremental increase so that you're never going to be penalized and having to pay higher real estate taxes because the land has been changed, it now has a solar farm on it instead of an agricultural use. And then there should also be a provision in there that says that any liens placed on the real property due to the developer's activities have to be cleared by the developer within 90 days. And if it's not cleared by the developer within 90 days, that they have to put up a bond to clear that lien. Because even if you had nothing to do with it, mechanics liens for non-payment of labor or materials or suppliers goes against the real property owner, not the operator. So you want to make sure that your property isn't going to be burdened by anything like that. You also want to make sure that there isn't any provision in there that says that the developer can seek a rezoning of your land at any time, period. We talked about removal and decommissioning. One of the things that you want to think about as you look at the lease and work with your particular developer is who's going to maintain what. So if there are roads or there's setbacks, let's say there's a 50-foot setback from the property line, that's not enough land for you to do anything with, except that you'd have to continue to mow it. So we usually always negotiate with the developer for the developer to maintain all setbacks. Or if you want any particular screening put in around an existing residence, that the developer would be required to maintain that screening. In other words, replace plants that die or trees that die or whatever it is during the life of the project. Or if there is a ditch, public or private, that runs through the center of the property, but the developer is using all the property on each side of the ditch, that the developer is going to maintain that ditch. In other words, you don't want to have to maintain the equipment and costs of a farming operation for a small piece of land. So those are the kinds of other things that you might want to think about. And then the last thing I'll mention, I don't have a slide on it, but a lot of times we can get through all of these little nitpicky issues, and they're not nitpicky, they're important, on the lease. And it comes down to, is this a good thing or a bad thing from an economic viewpoint of the farmer? And that question really comes down, is sometimes harder to figure out on a solar farm than it is on a wind farm, because like I said, the wind farms tend to lease the entire acreage. But then they don't pay you a lot per acre. But if you get a generating unit, one of the turbines on your property, then you get the big money. If you don't get a turbine on your property, then you may not get the big money. On the solar farm, it's, if you've got 100 acres and they ultimately they lease all 100, but then they release 50 acres and they only pay you the big money, the $1,000 per acre payment when they start operating on 50 acres, because that's the only area that they actually put solar panels on. Then you have to decide, am I better off with $50,000 a year on those 50 acres, guaranteed with a 2% increase per year, understanding that that's all profit, absent your real estate taxes, because you don't have any inputs or costs or equipment, especially if you've negotiated with a developer to maintain the rest of it. Is that better than a farming profit on the 95 tillable acres? And those are only things that each individual farmer can determine. So it comes down to an economic decision. And I've had clients go both ways. I've had clients say, even if at the amount of profit that I'm making on my farm right now, even if they only leased 30, if I only paid me for 30% of the acres that I've got, I'd still come out better than what I'm making as a farmer. And so they're willing to do it. Others who've got, large farms, 1,000, 2,000 acre farms go, no, I'd make more money as a farmer, and I don't want the uncertainty of having stranded land that it doesn't have any economic value anymore that I might have to maintain. That's the end of my presentation. It's kind of hard to just talk into the Netherlands without any feedback. So hopefully I've made some sense to you.
Thank you
Just
very
check
much,
on the-
Terry. Jasmine, can you hear me okay?
Yes,
Great.
just a moment.
Terry,
while
again,
I-
thank you very much. As I mentioned, we're going to have we've got a number of really good questions we're going to get to in just a moment. And before we do that, we just want to take just a little bit of time here for our partners that I mentioned at the beginning of the program. Certainly Indiana Farm Bureau. Unfortunately, Andy Tower is tied up with a board meeting right now. But I think this group is well aware of the grassroots membership organization origin of Indiana Farm Bureau, advocacy, the dissemination of good information about agricultural policy issues, legal issues, and so forth. We're a membership organization, 3250. And it, helps us create educational programs like today to make sure that your voice is heard in our State House. I hope if you're not already a member, I really hope you will consider it. And the information here on this slide, infb.org, is a good key to get in and look at that information. Become a member if you're not. We would certainly really appreciate that. I know Andy apologizes for not being able to be here with us this morning. The next slide, Jasmine. As I mentioned, my name is John Shoup. I'm an attorney and director for the Indiana Agricultural Law Foundation. It was created by Indiana Farm Bureau. We do two things. We do educational programming, much like today, on hopefully interesting, actionable legal subjects like the subject of Terry's presentation today. Just a real quick commercial. This summer in July, there'll be more information about it. Estate and succession planning for the family farm. I think that's a good example of the kind of programming that the foundation wants to be involved in because it impacts every farm in the state. Hopefully some of our attendees today would be able to attend that as well. So along with educational programming, we get involved in litigation, precedent-setting litigation that is significant and impactful to agricultural stakeholders. I've got my contact information here at the bottom. If you have questions about the foundation, or in particular, we've had one of the biggest cases we've been involved with in the last 5 years, the Hemsel right to farm case in Hendricks County. I'd love to talk to you about it. Again, if you're an agricultural stakeholder, it's a meaningful case, and I'd be happy to share more information about that with you. My contact information is provided here, and don't hesitate to reach out if you've got questions or ideas for additional programming. And also, I want to turn it over quickly to Sarah from Indiana Acre to talk briefly about her organization.
Thank you, John. Good morning, everyone. And we're really glad to have you joining us today. We've got almost 80 people on here. So obviously the alternative income streams and the ideas that our speakers are presenting is resonating with a lot of you out in the field. And we're glad to have you. Thanks a lot to Terry for her presentation. John is going to field questions in just a moment, but I wanted to share quickly about our involvement. I'm the founder of Indiana Acre, and our acronym stands for Agriculture Coalition for Renewable Energy. So the idea behind this, we just started back in 2020. So we're a new organization, but we already have dozens of farmer members throughout the state. We are made up of farmers as members, but if you are interested in renewables as it relates to being installed and used on agricultural lands and in rural communities, you can also join us as what we would call a stakeholder as part of our organization. So our idea is really that we want to represent farmers and landowners in Indiana that have an interest in clean energy and renewables, and yet also really want to support that kind of right to farm feel, the opportunity for them to proceed with these projects. And we want to help you if you're interested in these kind of things, understand how you do it, the questions you may have, connect you with the right resources. And so really we're a grassroots advocacy and resource-based organization. We do not have any costs to join, and all growers and rural landowners are welcome. So we'd love to have you join. We will be doing and continuing to do many things like this. Educational programming is a big piece of what we do. We also have a newsletter that we send out monthly. We've got some social media involvement to keep you informed. And we do have regular member meetings. Right now we're about quarterly. We've got the word on here, roundtables. And that's really just a member discussion of a current topic. For example, last year we spent a lot of time on those roundtables on solar siting and how that looked, and questions and connecting people. So yeah, we're here to connect you with state, local, national resources and network with you with other growers in Indiana and their experiences. I also want to introduce Jasmine Eisinger. She's on there. Wave at us, Jasmine. You guys had her on last week as your Indiana Acre representative if you were on last week's call. She's an integral part of our group, serves as the program manager, and really helps us put our information forward. So please join us. You can join at indianaacre.org. So just let us know. You can also type in the chat, I'm in, I'd like to be a member, and we'll just start sending you our monthly newsletters and all of that kind of stuff. So real quickly before I go back to the Q&A, I want to tee up next week's program that we're going to be moderating for you. So we do have 3 of these in a row, as John said, and next week, same time, same place, we're going to be having a farmer panel. So we're making good on that commitment that we want to connect farmers and provide resources in the renewable energy space. So we will have 3 farmers for you next week. I'll moderate that discussion. All of these growers are Indiana growers that have a pretty diverse experience in what they've done. So we'll have one grower who is in the dairy business and has a digester. We'll have a grower that is in the pork and row crop business that's been part of a large wind farm project. And we'll have a grower that's a row crop farmer that has some solar and has been really involved in the advocacy side of things. So you'll want to hear the good, bad, and ugly and the interesting from these 3 growers. And that's what our session is going to be about. We're going to let them talk and tell you their experiences. And you guys obviously can ask them questions with the format we have. So thanks a lot to Farm Bureau for partnering with us, Jasmine for all of her work, and do join us, become a member of Acre. We'd love to have you. John, let's get to those questions because we have a lot of questions for Terry in the queue.
Thank you, Sarah. Okay, I'm just going to get right to them here. The first question, and I think Terry, maybe you mentioned this, but what about grazing of livestock on solar farms? Is that a lease provision? What do you hear about that?
It is beginning. That started a couple of years ago with some test plots where they were leasing, allowing grazing of sheep, certain size sheep, not goats, around solar panels. There's one farm in Indiana that we have negotiated a provision that says that the developer will work with the farmer on creating a grazing test plot with the solar panels. So that is something that is being used out. It's something you can talk to the developer about. It's going to depend on whether they're receptive to it or not. It's going to depend on their design and the technology that they're going to use in their specific kinds of solar panels. But there's a lot more. One of the big complaints about solar has been that it removes the agricultural use completely. And so there's been a lot of movement by the developers and the solar companies to develop more agricultural friendly types of technology, including higher solar panels that allow for specialty crops to be grown underneath in the shade that actually works better than some of the other things. So
Okay.
I think this will become something in the future for sure.
A related question, Terry. One of our attendees asked about solar panels that are able to be raised. that would allow for more room and space and so forth underneath. Is that something you've heard of, or is that a thing?
There are solar panels that are now, I think I've seen one solar farm in the east that they have raised the panels up, kind of like they're building taller wind turbines. They've raised the panels up to like 15 feet, and that allows for more diversified agricultural use underneath. I haven't seen anything like that yet in Indiana. It's more costly, of course, when you raise it up like that. And given the fact that the primary opposition to solar development is visual impact, increasing the height of the solar panels would obviously increase the visual impact of a solar farm on those ag communities, and that might offset any benefit that you'd get from continuing the ag use. But
Okay.
it's certainly something that they're all looking at.
I understand. Thank you. A question from Southern Indiana reads that they do not have mineral rights, oil and gas, to their land that a solar company is interested in leasing. They mention that there are a number of oil and gas wells in the area, but there hasn't been any drilling for about 20 years. Would the solar company have to deal with the company or individual that owns the mineral rights rather than the surface rights?
No, not necessarily, but there would probably be a negotiation. If you have, when you say you don't have the mineral rights, I don't know if they mean that they sold them, they sold the mineral estate, or if they've just leased the mineral estate. If they've leased it, you'll have to disclose that to the solar company. The solar company will then look at the lease, and I'm glad somebody asked this question because I should have talked about it. We did have an issue with a parcel of land that was going to be leased for a solar farm that had been used for an underground coal mine at one point in time. And the landowner was concerned because there was an indemnification provision in the lease that said that the landowner was going to be responsible to the solar company for any damage to the solar facilities, whether it occurred after the lease was there or something that had happened before the lease took place. Which, in other words, if there was some kind of subsidence or something from the coal mine, the landowner has no way of knowing if that would ever happen from this old coal lease. The landowner was going to be financially responsible for those damages. So we were successful in negotiating a provision in the lease that carved that out, that said the solar company is taking the land subject to the former coal lease. And if there are any damages to the solar farm related to the earlier leasing of the land, the landowner is not responsible. So if you have a current oil and gas lease, you just want to make sure that the solar company is aware of that. They may talk to them and just say, because usually the lease will say that they can't do any drilling. Any drilling that occurs would have to be deeper than 500 feet. That seems to be the standard.
Okay. You mentioned, Terry, sometime the hopefully unlikely event that a developer files bankruptcy and the ramifications of that. Do you have any information or numbers about how often this has occurred or the frequency of a developer filing bankruptcy?
I haven't. I will tell you that most all of the leases, the developer, if it does file bankruptcy, there's a bank involved or a financing arm involved in there someplace. And the leases allow the financing entity to come in and take over the lease and make all the payments and that kind of thing. So, but I will tell you that I'm also a business bankruptcy lawyer, and I've represented companies in bankruptcy, and bankruptcy is a world unto itself. It can happen, but there have not been, as far as I know, unlike the coal industry where there have been a lot of bankruptcies, there have not been, in oil and gas too, there there have not been a statistically significant number of bankruptcies of solar or wind farms.
Okay. Terry, also you mentioned some consolidation in the energy company business. I can remember when I was in private practice 10, 15 years ago, there were a number of companies, and landmen would come out with the intent to secure the land only to transfer it, assign it to, you know, maybe a third or even fourth party. Okay, I'm sorry. Like, are you finding that the likelihood that a lease would be assigned has diminished? That you're dealing with a company that has the intent to construct, operate, sell the power to the power grid, rather than the possibility of it being assigned?
You know, that's a good question, and unfortunately, the answer is yes and no. That's a question that I've gotten to where I just ask the developer up front. I just say, you know, okay, are you intending to own and operate this, or are you building it to sell to somebody else? And they're pretty upfront about it. There are specific companies that are primarily design, build, sell companies, and there are specific companies that are design, build, own companies. So I just ask that upfront from the developer, and they'll be pretty honest with you about what their intentions are, because they're not embarrassed either way. One of the things that is happening more often, though, that I'm beginning to see that I hadn't seen in the last 4 or 5 years, is the utility companies becoming the owners. And I think that's, in the long run, you may see a further consolidation in the solar and wind industry, primarily in the solar industry, where the utility companies will become the owner, and you won't have a lot of private operators anymore.
Okay. Another question, is the recording from last week's session going to be emailed to registrants? Jasmine answered this question, that she will share the link to the presentation and slides at the beginning of Q&A today. Maybe that's already occurred and will be sent out in tomorrow's post-session email. So if you have any trouble receiving that, feel free to contact any of us, and we'll make sure that, you know, that we get that taken care of. Question about government support of wind and solar projects, Terry, and the possibility that that could change. You know, the level of support, the amount of support, and so forth, maybe with the transition in administrations that we've just experienced. If so, you know, how can that be addressed in a lease? Is that something you consider when you're taking a look at a wind or solar lease?
I will tell you that if there is as far as the federal government goes, they're not going to have any impact on land use, and which is primarily how Indiana regulates wind farm and solar farm development, is through land use regulations. I think that there will definitely be more incentives to develop solar and wind and other renewable energies with this new federal administration. As far as, I think Indiana, I'm not sure what this current state law bill final resolution is going to be as far as encouraging solar and wind development. I found that it's much easier to negotiate a lease in a county that has addressed solar or wind ordinances. In other words, so that the county takes on some of the protections for the landowners, such as the decommissioning bond and the economic development agreement and some of the other things, setbacks, so that protect the landowner as well as the non-participating landowners. So it's not something that will directly affect the lease. I don't think that you know, at the end of the day, the lease is a private contract between two parties that has all the rights of a contract, and that the government's not going to be able to avoid it or void it based on, we're not going to allow solar farms. Now, the where I see the most pressure against wind and solar development is these citizen organized groups that are quite vocal and becoming more and more organized, and they're represented by lawyers, and they show up at hearings, and they're very vocal about not wanting these kinds of developments in their community. They don't want it in their neighborhood, or they like the view of the cornfield. They don't want it to turn into a solar panel field. And it depends on the local politics is probably the biggest determinant, more than the federal government or anybody else. It's going to come down to local elected officials and whether they're willing to grant whatever permissions or tax abatement or incentives that the developer needs in order to go forward.
Okay. Terry, do you, and maybe this is a CPA question, but is there any difference in income that's generated from a wind or solar farm versus a traditional row crop farm? Is the tax treatment any different of that income?
Not that I know of, but like I said, I'm not a tax lawyer nor an accountant. Probably the biggest difference is if you're being paid $1,000 an acre, you don't have any expenses to discount that income.
Okay.
So you can make $1 million off a farm, but once you take off all your expenses, you're losing money. So you don't pay any income taxes. But the wind and solar payments are pure income.
A county zoning ordinance traditionally, does a county zoning ordinance address the issue of a decommissioning bond? And again, I think you addressed this, but again, how does it affect the landowner? I think you talked about that, Terry, about the decommissioning bond maybe being a requirement from the local zoning ordinance, right?
Yeah, if the county has a zoning ordinance that addresses wind or solar, it usually includes a requirement for a decommissioning bond. And the way that works is that the bond, instead of being written in favor of the landowner, the bond or financial assurance is written in favor of the county. And the county then promises all the landowners in the project that should the developer fail to remove the facilities and restore the property, that the county will perform that obligation.
Okay.
And the nice thing about it is that it forces the developer to put the bond in at the start of construction, so that the landowner is protected all the way from construction through operation, as opposed to the individual leases in which the bond is usually not put in place until the 10th or 15th year after operation.
Okay. One question I believe you addressed is the assessed value of the property. I think you talked about this, Terry, that any increase attributable to the infrastructure of a wind or solar farm, that's a standard provision in your agreement, that increase is going to be covered by the wind or solar company, correct?
It should be in there. It should be in there. And if it's not in there, put it in there.
Gotcha. We've got a couple questions here, very, very similar, Terry, and maybe you'll have some thoughts on it. Maybe you can direct, to other resources. But I think this really gets to the crux of what we're talking about here with diversification. The question reads, if your land is worth $10,000 an acre now in 2021, and you sign a solar lease at $1,000 an acre, and I think you mentioned this, or this is kind of a number I've heard, you've got a 2% escalator in the agreement, that talks about increasing payments at that rate. How would you advise someone that asks you this question, Terry, which is, given that information, how does that compare with owning and farming the land over the next 20 or 30 years? Because these leases are long, as you mentioned, you started the program with. I mean, to me, that's kind of the analysis. If someone posed that question to you in looking at a lease, what would your response be?
Well, it really depends on your farming operation. I mean, I've seen successful, profitable farms that are 200 acres. I've got a client over in Ohio that farms 2,000 acres and they're losing money every year. So it really depends on the type of farming that you've got, operation. And if, you know, a lot of it comes down to the people that have signed up with these leases, for the most part, at least in my experience, and it's not everybody, but because there've been some young farmers, but it has been middle-aged to older farmers who, you know, have a lot of acres, don't have a younger generation coming up, want some kind of long-term security on their property. It allows them to keep the land in the family and produce income for a long period of time. And they're willing to, I had one farmer tell me, I'm willing to forego the every 8th year when I make money, for 8 years when I'm my 8th year when I make a lot of money farming, for 8 years of making good, decent money farming. So like I said, in most of these leases, you've got not only the 2% escalator per year, so you're supposedly, and the escalators are different. Sometimes they have complicated formulas, but that's to protect the farmer against inflation on a static payment. But then there's usually every 10 years a bump up in the base of $100 or something. And that's to compensate the farmer for the increased appraised value of the land. But, you know, if you have a prime farmland, very profitable farm, and a good succession planning that's, you know, for the next 50 years, you think that farm's going to be profitable, then, you know, you've got different economic considerations that you want to put forward.
Okay.
So it's really a very personal decision, and it depends on your long-term goals and your risk tolerance and various and sundry other things that are personal with any business that's going to take on a new line or change the way it operates.
Jasmine, a quick question here. We're getting up to the noon hour here, but we've got a few more questions. I'm certainly fine, you know, carrying on. We're not going to get booted off at noon, right?
So I think we're okay to keep going a couple extra minutes.
Okay.
But thank you for checking.
Okay. A good question here about environmental issues. If there's leakage from, you know, chemical contamination attributable to the solar panel, who is responsible for those damages, Terry? And I think you talked a little bit about that with some of the lease provisions.
It should be the developer would be responsible for that. That's in the indemnification provision. And one of the things that you want to make sure of when you look at those provisions is that they are mutual, that they include both negligence and intentional damages, and that they're carrying sufficient insurance to pay for it. And there's an odd quirk between the indemnification provisions and the waiver provisions, where I talked about, you know, I said that the owner waives health effects, because you want to make sure that the waiver of health effects does not include an intentional or negligent chemical spill or chemical contamination, so that it's only those, you know, you're only waiving those physical effects of vibration or sound or that kind of stuff, but not any kind of environmental accident.
Okay. Just to the group, in case we do get kicked off at 12, thank you so much for attending, and we look forward to seeing you, as Sarah mentioned, for an excellent program next Thursday. But I'm just going to continue to work through some of those, some of these questions. Terry, any information about, I think one of the statements that you hear is the impact on property value for an adjoining landowner to a solar or wind farm. Do you have any information or any thoughts on that?
You know, that's one of those things where there are research papers on both sides that will say there's no impact, there is an impact. So I really can't give you an answer related to that. There's studies, I can't give you a definitive answer. I do know that a recent trend has been for the solar developers and the wind companies to offer what's called a good neighbor agreement to adjacent property owners who are not participating in the project, but who may be impacted by the project. And that can range anywhere from an annual payment, essentially a nuisance value payment to the landowners who are not participating, to a payment of a certain percentage of the appraised value, such that they'll get an appraisal of the value of the residence or buildings, and it usually goes just to a residence. It won't go to just blank farmland. Because if you're talking about property values, it's usually the value of a residence, but they could get the appraised value of the adjacent resident that's not participating and pay a one-time 10% of the appraised value to accommodate any loss in property value.
Okay. Terry, what and where is the largest solar farm that you're aware of in Indiana, and how many years has it been in operation?
I think the largest one that's currently built and operating is the one out by the airport. And it started building, let's see, I retired in probably about 2013. It's now in its third phase. I think there's a large solar farm scheduled to be built in Shelby County. I don't think it's gone off the ground. Northern Indiana, the utility up in Northern Indiana is building a pretty large farm, solar farm up there, but I think it's like 800 acres, but they've got 2 others underway or in process. And then down in Southern Indiana, there's 3 farms, all related to the Vectren Centerpoint utility. And those are going to be 2,000 acres, 1,000 acres, and I don't remember what the other one was. So the biggest one is probably around the airport at this point.
Okay. Terry, you mentioned failure to pay by the company being one of those limited circumstances that would allow termination by a landowner. The question was if that includes failing to fix tile, fence, and other infrastructure that maybe were damaged. How would you look at that issue versus the payment issue? Do you think that failure to do these things might be a condition of termination as well?
Well, unfortunately, at least in the leases that I've seen, the only right to terminate is failure to pay. If in some cases it has been, if you fail to, there's 2 kinds of default under a contract. There's a monetary default, which is a failure to pay. And then there's a non-monetary default, which is a failure to perform the other obligations, like fix damaged tile or pay crop damages or something like that. The failure to pay is usually a time limited, you have a time limited period in which you can cure, whether that's 30 days or 180 days. And if you don't pay during that period of time, then the contract party that's not in default can terminate. The non-monetary defaults usually have a much longer time period in which the defaulting party can cure. So if there's damaged tile and the farmer wanted it fixed within 30 days and the wind farm guy says, it's going to take me longer than that, as long as they continue to make progress toward fixing it, then you're not going to have a right to terminate. And on those kinds of defaults, you usually have to go to court and sue in order to terminate the contract.
Okay. A question, Terry, about carbon reduction and sequestration leased by a landowner, and the impact, like how do you think that would be viewed if there was some kind of a process in place regarding carbon? How would a wind or solar lease impact that, do you think?
So you've leased the underground storage area for carbon sequestration?
I think so. That, I just read the question, but that
I
just,
think I'd look at that more, I look at that the same as a mineral lease, that if you're leasing the third estate, you know, every piece of land has 3 estates. It has the subsurface estate, which is usually the mineral estate. It has the surface estate, which is where people build on. And then it has the estate above it, the air estate. And so each one of those 3 estates on any one particular piece of land can be leased separately to different entities. So if you've leased the subsurface estate for carbon sequestration, when you want to lease the surface estate, whoever was in there first would have to negotiate with the current leaseholders so that they don't interfere with each other. It's my understanding. I don't know that any solar or wind farm is pairing any carbon sequestration efforts with their operations. They're more likely to pair battery storage, and that's something we didn't talk about, but it's something that landowners need to be aware of and to ask the question, are you planning on using commercial scale battery storage? And if you are you carrying sufficient insurance for it? And are you thinking about putting it on my land? So it's one of those questions I should have put in there. Forgot.
Jerry, one last question. Again, we really appreciate the overtime.
No problem.
Really appreciate it. One last question. It talks about concerns from citizens about decommissioning and landfills not accepting panels or turbines. And again, the question is, how do we know that the ordinance or the plan that will allow for this to really happen? And the final question in this regard is, there haven't been many decommissionings yet, right? And what do you think? Do you?
None that I've and I don't, I'm not aware of all the things that are happening across the United States. So there could certainly be situations where the decommissioning, the developer walked away from it and didn't do their job, and there wasn't a bond in place, or if there was a bond, it was insufficient. And so I'm not saying that this has never happened, but most of the decommissioning bonds are structured so that they're 125% of the value of the cost of decommissioning, less the salvage value of the panels or the turbines. So, and they're supposedly put together by engineers who are useful or successful, experienced in this type of area of creating this. Now, unfortunately, right now, most of those studies are put together by the developers themselves. So it's hard to know whether they're going to be sufficient or not. And, there is a situation right now where and it kind of comes and goes, whether it's difficult to recycle solar panels, or whether you can find anybody that will take a solar panel for recycling. But, 3 years ago, that was not the case. So I guess my thought is, get as much certainty as you can, get as high a bond as you can that's reasonable. If the salvage value, those bonds, the amounts of the bonds should be reviewed every 3 years or 5 years or whatever, and adjusted. And if it's at that point in time, there's no market for the salvage value, then the bond should be adjusted to remove that credit for the salvage value. But the best we can do is a bond is simply insurance against a future event that may or may not happen. And we never know if we've all carried the right amount of insurance.
Yeah, I think the bond example is a good one, Terry, in that at least there's something there up front to know that there's something there. One of the things I always think about with law school is they didn't really do a good job of explaining the difference between liability and ability to pay. And so might be liable to do some of the failure to pay and so forth, but if they're bankrupt, or if they don't have the resources to pay you, that's a problem. And I think it gets to what you said earlier about knowing who you're dealing with. You know, do your due diligence to understand the nature and the, you know, the financial stability and so forth of the company that you're dealing with. Sarah, I understand you have a question.
I got a question sent to me on text, and it may be a good type of question to wrap. For both, this could be for both of you, both of you being attorneys. At what point is the best place for that grower to come in and contact their attorney? I mean, is there a certain switch that flips that says, okay, this is the time when I really need to get with my attorney and share what I've got going on, or seek help?
Well, I would not sign a 60-year lease that hadn't been reviewed by an attorney. I mean, I just wouldn't do it. These are complicated documents. They're not simple leases. And I don't think there's an intent on the part of the developer to slide something by, but they're complicated and they should be reviewed by a lawyer. Now, when should you contact your lawyer and start incurring fees? I think the way these things happen usually is that there's a land guy that's hired by the developer that goes or sort of knows the area and goes around and talks to the farmers and maybe hands them a draft lease and talk to them about the project. And so then you can start talking with your family and figuring out if this is something you really want to do or you really want to think about doing, and you talk to your neighbors and see who else wants to do it. And if you're going to be serious about it and you think that you might really consider it more than 50-50, then that's when you should take it to your lawyer and have them review it. And hopefully they'll charge you a flat fee, and that way you can get all your questions answered.
I agree, Terry. And certainly our relationship over the years, I often get the first call from folks who are considering or at least have interest. And often we wait to engage you when a lease has been presented, or at least pretty close to what a final lease is going to be. And I'm sure our group today is more sophisticated than this, but I've seen over the years, not only with wind and solar, but any contract, the focus tends to be on how much am I going to get paid. And I think Terry did a great job today explaining that there's a lot more to it. You know, it's especially if we're talking a 40, 50, 60-year lease, there are certainly a lot of considerations that you want to have buttoned up before you decide to move forward. It just enables you to make a more informed decision. So I completely concur with Terry. And with that, Terry, I want to thank you again for the presentation. Awesome, good information. As we mentioned before, Terry's slides and recording the presentation will be made available. Can't wait to get to next Thursday. As Sarah mentioned, I think it's going to be a fascinating wrap up to our 3-part series. And we certainly hope to see all of you there, and tell your friends. Tell your friends we'd like to get the maximum amount of people there. And we look forward to seeing you all next Thursday. So with that, we'll sign off, and thanks again.
Thank you.
Thank you. Great job today.